Hai, Assalamualaikum warahmatullahi taala wabarakatuh. We are from Group 10 and today we will be presenting about strict liability, which is defenses. So this is our presentation agenda, which is we will be presenting about definition of defense and continue by concern of plaintiff. The third one is act of third party. The fourth is common benefit. And the fifth is act of God and plaintiff default, and last but not least is statutory authority. So first and foremost, I will introduce my team member, which is me, Muhammad Sazni bin Zailil, continued by Siti Nurul Syafiqah, Muhammad Ishad, Natasha Nabila, and Aminur Azim. So for the defenses, I will pass to Ishad Nasar Asfihan to explain more about it. Thank you.
Okay, thank you, Sazni. Okay, thank you, Sazni. So, what is defenses? General defenses are set of excuses that you can undertake to escape liability. In order to escape liability, in the case where the plaintiff brings an action against the defendant for a particular tort providing the existence of all the essentials of that tort, the defendant would be liable for the same. So, concern of the plaintiff. The plaintiff's concern to be defendant's actions or conduct is a defense to a suit for any intentional tort. There are two general types of concern that can be given: express concern and applied concern. Express concern is when the defendant actually says that he is willing to submit the plaintiff's actions. So these are the two types of concern. The first one is express concern, concern that is clearly and unmistakably stated. And the second one is implied concern, concern inferred for someone's conduct rather than from his direct expressions. So this is the example cases of concern of the plaintiff. So the case is Sheikh Amin bin Saleh and Chok Hap Sang. So for example, the case of Sheikh Amin bin Saleh and Chok Hap Sang, 1974. In the case, the plaintiff owns 8 houses and he leased 4 of them to the defendant. The defendant built a big brick oven at the back of those premises and made illustrations to merge the 4 houses into one unit. The purpose the defendant used the premises is for a bakery, and the plaintiff knew about all 8 premises being destroyed, and the source of the fire came from the defendant's oven. Therefore, the plaintiff sued the defendant to demand compensation for the damage caused by the fire. However, the tort of the law states that a person who consents to the dangerous thing being brought to a place from which it may cause him injury, if it escapes, has no right of action unless he can prove negligence. Thus, the court held that the defendants were liable for negligence, not a strict liability, because the court found the plaintiff has consented the defendant using the premises as a bakery. The defendant will only have to bear the cost of rebuilding 8 destroyed houses within a reasonable period. So, law of trust is an equitable obligation binding a person, a trustee, to a deal of property over which he has controlled the trust property for the benefit of persons of whom he may himself be one, and any one of the beneficiaries may enforce the obligation. One of the examples is a testamentary trust. A testamentary trust is a trust that is created under a will and that becomes active after the testator's death. when the trustee death, the trustee must distribute his property to beneficiaries following the trustee's will. If the trustee does not distribute according to the will, the beneficiary have the right to sue the trustee. So I will pass common benefit to Tasha.
Hi, I am Tasha and I will explain regarding the common benefits. The most common category is the employment relationship in the private sector between an employer and an employee. Given that this is a contractual relationship, the terms of the employment contract determine the rights and duties of the employer and the employee thereunder. Next slide. So common benefits recognizes employees' implied rights and duties, terms of mutual trust and confidence, and the third one is private sector employment relationships, and employees have a right to register a trade union. Next slide. I will explain. This is the example of the cases. 10 of the cases is about Maritime Intelligence, Sendirian Berhad and Tan Aget. 10 the respondents was dismissed on the grounds of misconduct. When the dismissal was referred to the industrial court, the company raised for the first time in the pleading that the postgraduate degree of the respondent was not from an accredited university. This was not the ground of dismissal.
Okay, hi, my name is Amin Azim. Okay, I will explain about act of a third party. Tort laws involving third party in domestic harassment. For the civil court of the section 498 of the penal code, like as the offense of disturbing a person's household so as to lead to divorce, and the punishment is imprisonment not exceeding 2 years or a fine of 3,000 ringgit or both. For the Sharia court on offense under section 32, which is to proceed to run away, take away or influence a married woman to leave the household. For the offense of section 33, which is to prevent a lawfully married couple from living as husband and wife. And the offense of section 34, which is to incite couple or pursue any husband or wife or divorce or neglect his duty to his spouse or family, and the punishment to be imposed on the offence in accordance with the state section is imprisonment not exceeding 3 years or a fine not exceeding 5,000 ringgit or both. Next slide, please. Okay, this is example of the cases. For the cases of Princess Sarah Liana and third party. In the still hot and viral case or harassment of actress couple Putri Sarah Liana by a third party, he admit to taking legal action and lawsuit through his lawyer against individual or a consider base and disturb his emotion, physiology and peace. Next, I will pass to the next presenter.
Thank you, Amino Azim, for your explanation. So now I will be presenting about the act of God. So what is act of God? So act of God can be defined as an extraordinary occurrence of circumstance which could not have been foreseen, and it's also as an accident to a natural cause directly and exclusively without a human intervention, and which could not have been avoided by any amount. Then these are the cases that we have chose for this research, and the cases is about Kalulal versus Hemchen AIR 1958, which is the case of the wall of building collapse on a day when there was a rainfall that result in the death of the respondents of two children. And in this case, the appellant could not take the defense of act of God, as that much of rainfall during the rainy season was not something extraordinary. And then the appellant was therefore and held liable. And the second case that I chose is Nichols versus Marshland, 1876, which is the defendant creates some artificial lake on his land by damming some natural streams. And once there was an extraordinary heavy rainfall, the state to be the heaviest in human memory, as a result of which the embankment of the lake gave away, and the rush of water washed away for bridge belonging to the plaintiff, and it was held that defendant was not liable for the loss. So for the plaintiff default, I will pass to Siti Nur Shafika to explain more about it. Thank you.
Okay. Thank you, Sazni. Next is about a plaintiff default. So plaintiff default is where damage is caused by the plaintiff on action or a wrongdoing that he will not be compensated if the plaintiff contributes to an damage. He may be held to be contributory negligent under Section 12 of the Civil Law Act 1956 if, however, the damage however the damage should not have been incurred, but for the sensitivity of the plaintiff property, the law is rather unclear as to whether the defenses may be raised successfully. Next. The case is Bird v. Holbrook, 1828, which the plaintiff, the trespasser over the defendant lands, was entitled to claim compensation for injury caused by spring set by the defendant without notice in his garden. And according to Sir Frederick Pollock, when the plaintiff himself is a wrongdoer, he is not disabled from recovering in tort unless some unlawful act or conduct on his part is connected with the harm suffered by him as part of some transaction. And other example is a bridge under control of defendant gives away when an overloaded truck belonged to the plaintiff passes through it. If the truck was overloaded, contrary to the warning notice already given, and the bridge would not have given way if the truck were properly loaded. The plaintiff wrongfully act is the determining cause of accident. So that's all for me. Next, I will pass to Ishad.
Okay. Okay, thank you, Sharika. So the statutory authority. Statutory authority refers to the powers and duties assigned to a government official or agency through a law passed by Congress or a state legislature. It is also known as a statutory grant of authority. At the federal level, Congress creates and authorizes agencies to administer government programs and enforce the law. So this is the example cases for the statutory authority, Ryan and Victoria City. The appellant was injured when he was thrown from his motorcycle while attempting to cross railway tracks running down the center of a street in downtown Victoria. The front tire of his motorcycle became trapped in a flangeway gap running alongside the inner edge of the street grade tracks. The motorcyclist sued the city and the railway companies which owned and operated the tracks. The railways denied liability on the ground that his tracks were authorized by and complied with all applicable statutes, regulation, and administrative orders. The trial judge held the railways and the city jointly and severally liable in negligence, the former for maintaining dangerously wide flangeways and the latter for failing to warn of the hazard. In addition, he held the railways liable for nuisance. The British Columbia Court of Appeal set aside the nuisance finding and held all of the respondent liable only failure to warn. The Court of Appeal also found the appellant to be contributory negligent and liable for 50% of his damages. At issue here was, first, whether the railways were liable in negligence. Under a long-standing common law rule, the standard of care owed by railways to the public was normally limited to the discharge of statutory obligations. The question is whether that rule should now be discarded, and if so, how statutory compliance should be affect the assessment of liability under ordinary negligence principles. The second issue was whether the railway were liable for public nuisance. Again, the railway disclaimed liability on the ground that the tracks involved were authorized by statute and regulations. The question arose as to whether the defense was unavailable because the hazard posed by the tracks was not an inevitable consequence of exercising statutory authority. The final issue was whether the Court of Appeal, by reversing the findings of the trial judge with respect to contributory negligence, the finding of liability of failing to warn the appellant of the hazard created by flangeways was not challenged. So that's all. Thank you for me.
All right, thank you, Isha, for explanation, and that's all from us. All right, thank you for listening. Assalamualaikum.